Thank you very much. So I'll be here talking about shadow regulation. You're probably wondering what that is, and I'm going to explain more of that later. But I'll also be talking about other ways in which we regulate the internet. And this talk's probably going to be a little different to some of the other talks that you hear during this research exchange seminar series, because most of them are probably going to be talking about this, the technical infrastructure of the internet. This is a visualization of what the internet as a network would look like if you connected all the nodes together. You can see how there are certain clusters, but there's no central point. There's no hierarchical authority in terms of the technical infrastructure of the internet. And back in the day, we used to think that maybe the social infrastructure or political infrastructure of the internet would also be governed in the same way. That there would be, rather than a hierarchical set of governments or a world government or a world parliament of the internet, we would have what one of the founders of VFF, John Perry Barlow, described as a civilization of the mind in cyberspace, which would be an independent, self-governed internet, where the way that the social infrastructure of the internet is governed comports with the technical infrastructure. In other words, it's decentralized, it's open, it's egalitarian, it's cosmopolitan, there's no national borders. So this was the dream, that we would have kind of a self-governing, self-regulating internet. And in fact, this diagram is one that I used on the front cover of a book that I published in 2008 about this concept, about how we could develop a self-governing global internet. But even then, in 2008, that was beginning to look like an outdated notion. And it turns out that this is more like the map of the governance of the internet. It's the same as our geographical map of the world. Countries of the world are trying to make their own laws for the internet. In 2005, the World Summit on the Information Society, which was a United Nations summit, passed a resolution that said policy authority for internet-related public policy issues is the sovereign right of states. So this was the states, the governments, putting a line in the sand and saying, no, we're in charge, you're not going to govern yourselves. But that's not a very good fit for the internet as we know it. The idea that states are the only international actors is a very old idea. It dates back to the Westphalian system of state sovereignty from the 17th century, which was illustrated by the concept of billiard balls on a billiard table, where each ball represents a country, a nation state, and these nation states are supposedly autonomous, atomic, and impermeable. They make the laws that governs what happens to their citizens, and the intersection between those states is just in the nature of treaties and trade agreements, and other than that, they're self-governing. Well, that doesn't work so well on the internet, because nation states are not the most important actors on the internet, by and large. Private actors tend to be more influential and more important. An illustration of this is that one of the old nation states, Denmark, has actually recently appointed an ambassador, not to another country, but to the tech companies. They have an ambassador to Google and Facebook and Twitter. So this illustrates very vividly, I think, that these private entities are now as important actors on the internet as nation states, if not more important. Facebook is one of the most obvious examples. You know, they have more members than some countries have citizens, right? So the policies that Facebook makes have effects on millions of users around the world. They don't have any sort of democratic process for making those rules, and there's a question about whether they should or shouldn't. Certainly they should comply with human rights, but in terms of the influence that we have through democratic processes on what Facebook decides, that's very minimal. There's no parliament involved, and Facebook isn't directly under the control of any government. However, it is indirectly under the control of all of the governments whose countries it operates within. And this is where you have a little point of pressure that the old Westphalian state system can exercise over the new world of the internet, because they can say to Facebook, well, we want you to enforce our laws, and if you don't, then there will be consequences. An example. This is what happens when content is taken down from YouTube under the Digital Millennium Copyright Act. The Digital Millennium Copyright Act, or DMCA, is actually not an international law. It's a law of the United States of America. And yet, most platforms around the world, whether or not they're based in the USA, will follow the DMCA as if it was a law applicable to them, which is very interesting. Part of the reason why that's possible is because the United States is a very powerful country. Another reason is that it's just simpler for them to assume that there is one international law called the DMCA, even though that's not the case. It gives them a reasonable sort of benchmark about how they should be removing content for copyright infringing reasons, and so they just follow it, regardless of whether it's legally binding on them or not. But the US is only one country. There are about 196 countries in the world. What about other countries? So does anyone know who this is? It's, anyone? Ataturk, exactly. It is Mustafa Kemal Ataturk, the founder of the Turkish nation. He died in 1938. But in Turkey, it's still illegal to criticize his memory. In many cases, it could see you being charged with a criminal offense if you say something that dishonors the name of this deceased founder of the Turkish state. So platforms are frequently requested to take down content that is critical of Ataturk. And they have a choice. They can either do that, or they can risk being blocked by the Turkish government. And so in many cases, that's what they will do. They will take the content down, at least within Turkey. They will use a technology called geo-blocking, which means that at least those who are accessing a website within Turkey will not see the criticism of Ataturk, but people outside may do so. Now, if you take this to an extreme, you end up with China's Great Firewall, where China doesn't even bother sort of asking platforms to take stuff down. They will just block you. Any platform that doesn't comply with Chinese laws will find itself outside of its national walled garden, where the only services that are allowed are those that do obey Chinese laws. So here we see an interesting combination of mechanisms of governance in place here. Firstly, we have the old mechanism of laws, Chinese laws, but we also see the use of a new mechanism of governance, which is internet architecture. And so this technical mechanism of blocking is being used to bolster the use of the old mechanism of laws so that those within China experience the internet as the Chinese government wants it to be. So that works fine for an authoritarian country, but it doesn't work so well for the countries of the world that like to uphold human rights, because we've decided that internet blocking is an infringement of human rights, and that's been a statement that's been made at a very high level within the United Nations, and there's a pretty broad consensus around that. So, so other countries don't have the same flexibility to just block content willy-nilly as happens in China, but that hasn't stopped them from trying. Even countries like Canada have tried. You're probably wondering what the hell this is. Some of you may have a better idea of what this is than I do, because I'm not so much of a technical expert, but the most interesting thing about this device is not what it is, but who it's made by. It's made by a Canadian company, as you can see at the bottom of that slide, made in Canada by a company called Equistec. Now, Equistec have a competitor who is supposedly infringing their intellectual property by selling a knockoff of this sort of device. And Equistec asked Google to block it because it infringed Canadian law. And Google did that, but Equistec was not satisfied. They said, no, 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 we want it blocked throughout the whole world. We don't want you to just geo-block this so that Canadians can't access it. We don't want anyone in the whole world to access it. And Google said, no, And so Equistec sued in the Supreme Court of Canada and got a judgment from the Supreme Court of Canada saying, yes, Google has to take this down throughout the entire world. Now, that's kind of dangerous, because what if a Turkish court says, no, you have to take down this criticism of Ataturk throughout the entire world? What if the Thai courts say, you have to take this criticism of our king down? What if Russian courts say, you have to take down this page which promotes LGBT rights throughout the entire world? So you see, this is where we have a real problem with countries trying to enforce their local policies across the entire internet. The only legitimate way, perhaps, for countries to do that in a legal way would be through an international agreement or an international institution, such as the International Telecommunications Union, the ITU. And there was an attempt to do that. Back in 2012, most recently, there was a big conference called the World Conference on International Telecommunications, where countries of the world came together to try to create an international legal instrument, or set of regulations to be precise, that would govern certain aspects of the internet in a way that it hadn't been governed before. And this actually caused a great fissure at the ITU, with some countries saying, no, this is a bad step. We don't want to go in that direction. We don't want to have the United Nations making rules for the internet. We think that's a bad idea. And so as a result of that split, that fell apart, and there was no unanimous agreement on a new set of regulations for the internet. We do still have an international institution called the Internet Governance Forum, which tries to suggest policies for the internet, but even it has shied away from actually making recommendations because it's such a politically fraught idea that an international body, even one that only makes non-binding recommendations, could start to make global policy for the internet. So that avenue too has failed for countries seeking to control the internet. However, they have tried at a smaller level to get agreement within a smaller group of states on rules for the internet. This is a protest that took place over an agreement that some of you may remember called the Anti-Counterfeiting Trade Agreement, or ACTA. So ACTA was an attempt by a smaller club of countries to make rules for the internet, particularly regarding things like copyright enforcement. And as you can see, it led to huge protests, and it was eventually abandoned after the European Parliament voted against it. But that is still an approach that some countries take. We had the Trans-Pacific Partnership recently, which fell apart after Trump decided it was not a goer. But that was also another attempt to include rules on internet data flows and copyright enforcement. And right now, as we speak, there's another attempt to do that through the renegotiated version of the North American Free Trade Agreement, or NAFTA, where the US, Canada, and Mexico may be making some new rules on data flows and IP protection. So, but it's a contentious battle, and countries haven't quite mastered the ability to make cross-border rules for the internet in an effective way. Here's another protest, which some of you may recognize. What is this? Anyone? It is Charlottesville, that's right. So here we're shifting tack a little. So if governments can't regulate the internet because it's problematic for them to do so, or difficult for them to do so, maybe the people can regulate it themselves. We've already covered two mechanisms of governance. Remember when I spoke about China and I said how they were using both legal governance and architecture as a mechanism of governance? There's a couple of other mechanisms of governance of the internet. And if any of you have read Lawrence Lessig's famous book called Code and Other Laws of Cyberspace, you may know what I'm talking about. There's norms, and here we see the force of norms. Norms are basically just a social agreement that we do not find certain content on the internet acceptable, and the pure force of protests and boycotts and social expectations around certain types of content can effectively force it off the internet. And there's another mechanism called markets, which works very effectively when you have private companies as the locus of control over the internet. Because this is what happened after Charlottesville. The Daily Stormer, which was a neo-Nazi website, got forced offline through a combination of these forces of norms and markets. Firstly, its web host GoDaddy dumped the Daily Stormer, claiming a terms of service breach. Then the Daily Stormer moved over to Google, which did exactly the same thing, and several times since then, they've gone to try and get other domain names for their website, and they haven't been able to find one, through a combination of the fact that they're just not accepted by internet users as a valid form of expression, and the market realities for these companies, that if they do host the Daily Stormer, they're going to be boycotted, they're going to have employees resign, they're going to have social media rise up against them. And so effectively, the internet has regulated this kind of content out of existence. Now, we hate neo-Nazis, obviously, but it's a problem when the forces of these kind of forces of governance, which aren't really accountable, can force content offline. Unlike laws, the force of angry consumers isn't really accountable in the same way. So it's kind of problematic when companies find themselves unable to host certain types of speech because they're afraid of the consequences. CloudFlare is another company which also severed links with the Daily Stormer, and its CEO mentioned how he was unhappy with having to do this. He said, literally, I woke up in a bad mood and decided someone shouldn't be allowed on the internet. No one should have that power, he said. So it's worth noting that now that CloudFlare has taken that step to disallow the Daily Stormer, they will come under increasing pressure from now on to disallow other sorts of controversial content. And they're going to be hard-pressed to say, well, no, it was okay for us to boot Nazis, but we're not going to boot some sexual minority, some other sort of controversial content, copyright infringements, whatever. It's going to be hard for them to make that case now. And it does illustrate how single companies have become real weak points for freedom of expression. And they can be targeted not only by public protests and boycotts, but also by governments. And EFF right now is fighting a law called CESTA, which is in fact aimed at influencing the behavior of a single company. That particular company is Backpage.com. It's a classified site which hosts, amongst other advertisements, it's hosted advertisements for sex services. And there are a lot of people who don't like that, and CESTA has been developed basically to combat that website from doing what it does. The aim of the law is supposedly against sex trafficking and in particular underage sex trafficking, and of course those are terrible problems, but the law doesn't target the sex traffickers, it targets the platform. And not only does it target this one platform, it targets all internet platforms just because of this one particular, albeit terrible, problem. So nevertheless, to say EFF does not think that this is a good idea. Now, finally, we are getting to shadow regulation. What is shadow regulation? I've given some examples of different mechanisms of regulation. Regulation through laws, through the internet architecture, through norms, and through markets. How is shadow regulation different? Well, shadow regulation is really a way in which governments and private actors get together behind the scenes to regulate internet content in a way that avoids some of the difficulties that they would otherwise experience in doing so, because they do it in secret. And because it's not just the decision of one company to disallow content, it's an agreement, sometimes called a memorandum of understanding or a code of conduct. It's something that brings together multiple companies or an entire industry in an agreement that is effectively a sort of monopolistic decision not to allow something on the internet. And that's especially dangerous, more dangerous than the decision of just one company like CloudFlare. It's especially dangerous when all of these companies get together where governments may also be applying pressure on them to reach an agreement to disallow content on the internet. So here's a diagram of the different weak links, what we call free speech weak links, that exist in between someone that is publishing speech on the internet, as you can see at the top, and the public that the speech is directed to at the bottom. You can see that there are multiple levels of at which censorship can take place in between. The web host that has the content, the CA means certificate authority that issues a security certificate to the website, the internet provider that is not the direct ISP of either the user or the publisher, but someone in between, they can be a pressure point. We've already seen that the DNS provider can be a pressure point because that was the case in the Daily Stormer incident. Then down at the bottom, you can see payment service providers. For example, Visa, MasterCard, PayPal, Venmo, those guys often have influence on where the content is available online because they can cut off the source of funding to a website. And even advertising networks as well work in exactly the same way. They can also be a pressure point or a free speech weak link. So when governments can't get what they want to do through laws or treaties, and where the actions of a single company aren't enough, what they will often do is come together, put the companies in a room and say, hey, we want you to make these voluntary measures. We want you to put in place these best practices, but we don't want to pass a law about it. We just want you to do it. So that's shadow regulation. I'll give you an example. This is the ISIS logo. It's not actually the logo of the ISIS terrorist group, though. It's the logo of the ISIS heavy metal band. And if you happen to be a fan of ISIS and you want to buy their merchandise online and you put in a PayPal request and put ISIS t-shirt, you're not going to see that money again. It's going to go into a hole somewhere because it had the word ISIS in it. Now, there's a list of words which the same thing will happen to. You know, Iran, we don't know what the list of words is because we haven't seen it, because it's a secret list. There's a secret deal that's been done between the payment processors and presumably the government, but there's no record of it because it's shadow regulation. So, and there's lots of reasons why your payment will be blocked by payment processors. If it has sexual content, there's a website called FetLife, which is a sexual community, fetish community. They had their payment processing services cut off by payment processors for obscure reasons. They hadn't clearly broken any terms of service. They weren't breaking any laws. They didn't have any child pornography. They didn't have any sex trafficking as far as anyone knew. I mean, there had been a complaint earlier that they had child pornography on the site. It was actually a cartoon of The Simpsons. This is also child pornography, arguably. Is it? I don't know. Maybe it's art. But I'm not the one making that decision. You're not the one making that decision. Even a court is not the one making that decision. It's a secret decision that someone else is making. Someone else is deciding that maybe this is child pornography and it shouldn't be allowed on the website. Maybe discussions of sexual fetishes shouldn't be allowed because even though they're legal, we don't like them. Now, who's making that decision? That's what we want to know. And that's why shadow regulation is really dangerous. Another case in which speech is frequently shut down pursuant to a secret agreement is copyright. Luckily, the public has become pretty wise to some types of copyright enforcement measures. Remember that ACTA protest that I showed you? That was basically about copyright. In the United States, we've also had laws on copyright that have failed, such as SOPA and PIPA, which were internet censorship measures. So, of course, since those measures have failed, the industry and the government have moved on to shadow regulation because they don't have to pass that through Congress. They just have to talk to a few people and get them to you know, make a special deal. So the United Kingdom government, for example, has had a little private negotiation with the internet platforms there, Facebook, Google, and they've all agreed, all the platforms have agreed to demote to an agreement that requires them to take action to lessen the visibility of pirated content on search engines. How do we review that if we disagree with it? We can't go to a court, we can't appeal it, because it doesn't go through the law. It goes through this secret backroom agreement. The Domain Name Association tried to bring in a similar secret arrangement to take down websites from the internet for copyright infringement on the advice of, guess who? The Motion Picture Association of America. And there already are 2 internet registrars that have private agreements with the Motion Picture Association of America to take down copyright material from websites. Not just take down the material, actually to cancel the domain names of the websites, can you believe? To suspend the entire domain because the MPAA says that there's copyright infringement there. Now, if maybe there is, maybe there isn't. Maybe there should be a court that decides whether there's copyright infringement or whether there's fair use. I certainly don't think it should be the MPAA that makes that determination. The Domain Name Association did take that out of their draft set of healthy domain standards because EFF drew attention to it. That's one of the few cases where we've actually scored a win against shadow regulation by bringing it to public attention, and there was an outcry and they took that out of their set of recommendations. But what they left in there was a similar set of recommendations about pharmaceuticals. So their policy on pharmaceuticals was written by the US pharmaceutical industry. You can't make this stuff up. It was literally written for them by a big pharma-linked organization, which says that Americans shouldn't be allowed to order pharmaceuticals from overseas, even though there may be nothing. I mean, it's technically illegal for you to purchase these from overseas, but it's not illegal for the foreign pharmacies to send them to you. And if you have a prescription and you send that prescription to a registered, accredited Canadian pharmacy, for example, the pharmacy will send you drugs. And they're not breaking the law in doing that. However, you can't do that because many domain registries will just drop those sites from the internet without a court judgment, without any due process. Even if they don't drop the domain name, you won't be able to pay for the drugs with your credit card. Why? Because there's a shadow regulation agreement between the credit card processors and Big Pharma that requires them to refuse credit card transactions from Canadian pharmacies. So, look, maybe they're right. Maybe there should be some kind of regulation of the sale of pharmaceutical goods on the internet. But it shouldn't be one that the US pharmaceutical industry controls, right? It should be some kind of balanced, multi-stakeholder process that decides on any rules that are going to govern the transactions over online pharmacies. So we are not saying that there shouldn't be ways of taking content down from the internet. We in fact have this set of principles which says exactly how you can take content down from the internet. It's based on human rights norms though, and it's not just like totally arbitrary like some of these policies are. We say if there is a court order, then an internet company should take content down from the internet in response to that court order. If there's a court order that applies to them, they have to follow it. Also, we go further than that. If the company has a set of terms and conditions and the content is against those terms and conditions, they are absolutely at liberty to remove that content as well. We only ask that they go through a process that follows some due process norms. So there should be notice to the person whose content is being taken down. There should be an opportunity for them to have that reviewed. There should be transparency. There should be an opportunity to give input into the process. So that's all that we're asking for. We're certainly not saying that illegal content should remain on the internet indefinitely, but there should be a defined open process for taking it down. And this doesn't always mean there have to be a shadow regulation style agreement across the whole of industry. It can just be a single company's policies are developed in accordance with the Manilla Principles. Often, you know, an industry-wide agreement is not a good idea, and it's better to just get consumers empowered to make their own decisions about what they do and don't want to see. So if you can give users the tools to create their own internet experience and to regulate their own internet experience, that may be the best option. However, there may be some cases where a global or regional or industry-wide agreement or set of principles is a good idea. And we think that so long as that agreement follows human rights principles and follows these three principles, we think that should be okay. These three principles we developed to suggest how you can reach an agreement that isn't a secretive shadow regulation agreement, but is actually inclusive and helpful to users. So firstly, all of the users who are affected, all of the stakeholders who are affected, I should say, need to be a part of the process of developing those principles. They also need to be resourced to be able to have their voices heard. And if you have maybe internet users and a powerful lobby group like MPAA or Big Pharma in the room, there's a power disparity there. So the second factor says you have to balance away those power imbalances so that the optimal solution may not be just the one that the most powerful person in the room wants. It may not be one that the MPAA wants. It may not be one that the US government wants. It's one where the best idea, the best compromise will be the one that wins through rather than just the one pushed by the most powerful stakeholders. And finally, if we are going to be developing a set of rules or principles that applies across the internet, then that whole process needs to be accountable. You can't have closed-door agreements like the TPP, like NAFTA. That's just not acceptable anymore. We've seen what happens with those sort of closed agreements. The protests, like the ACTA protest, that's what happens when you have closed agreements. It needs to be open, it needs to be accountable, and we need to be able to trust that an agreement that's made in this way is reflective of our interests. So I think I've just about run out of time, but I would warmly welcome questions from you. I think we have about 10 minutes left for questions. So over to you.
Yes. Do you have any comments on the situation with the socialist websites in the U.S. who are complaining that their hits to them have gone way down since April because of a silent agreement that keywords that are normally socialist topic words will be sent to other sites?
I'm not familiar with that, but I would be really interested in hearing more about that, and that is a concern. So our position, obviously, at EFF is we're a free speech organization. We think that regardless of whether content is true or whether we agree with it, people should have a right to say it. And whether the censorship is official censorship, government censorship, or whether it's private censorship, it can still be equally dangerous. That doesn't mean that we think every platform has to be able to host all sorts of content. If you're a platform and you decide you don't want to host content from right-wing, left-wing, or even content about dogs, maybe you're a website about cats, you have the absolute right not to host that content. But just make your rules clear and make sure that they're implemented in a fair way with a process of review. So that doesn't really answer your question because I'm not familiar with that exact case, but I would love to have more information about that. So if you can send me some more information, that would be really great.
I got it.
Yeah.
And thank you for the very interesting consideration. I am worried a little bit about the second bullet on your slide here, over there, the balance. While obviously it's reasonable to follow this way, I'm a technocrat. I'm not quite sure how can we enforce a process assuring the balance, and having all the experience nowadays with the rules of usage, which it is, you know, you swallow it or you die, you take it as it is or go home and give up all the navigation and whatever, unless you are ready to give your data. So yeah. Where is the balance?
Yeah, that's an excellent question. And so this is a summary of a longer paper, which in turn is a summary of a much longer paper, which I can refer you to if you're interested in reading some more about techniques that we can use to balance different interests. One of those is using techniques of deliberative democracy. And deliberative democracy, there's some work being done here in the Bay Area on that, at Stanford in particular, and also here, ways that even people who disagree very strongly can be brought into a setting where they speak respectfully to each other and learn from each other and actually come closer towards agreement. Even if they can't agree, there are techniques to make sure that they don't just shout at each other and they don't overpower each other. So yeah, there's lots more reading to do on that, and it's definitely the hardest of those three to do, I think, without question, but it's also critically important.
Hi, following up on the earlier point, you said basically you support the idea of free speech and the idea that, you know, if you're a private company, if you lay out, you know, your terms and services clearly, then, you know, as long as your users abide by that, you have absolute right over, what kind of content you might want to censor. But I'm thinking, because, the internet today, we're not talking about, a million small private internet companies, right? We've got major points of centralization.
Yes.
So there's this antitrust problem, because how much, choice do the users really have over these terms and services? And in that respect, do you think kind of maybe some kind of antitrust regulation or some kind of public utilities regulation might be needed to kind of convert these points of centralization into more public kind of outlets?
Yeah, well, if I suggested public utilities regulation of internet companies, I would get slaughtered when I went back to the office. I think no, except to the extent of net neutrality rules. So net neutralities are a form of public utility regulation of internet at the infrastructure level. But certainly we wouldn't suggest that the same sort of thing applies at the content level to the platforms. There may be antitrust laws that apply to them, and in Europe, certainly, they've been very vigorous in pursuing antitrust remedies against Google and Microsoft in the past. But also, you're right in saying that there should be a higher standard of due process expected from companies that are central points, like everyone, to communicate with their families, kind of has to have a Facebook account, right? If you can boycott Facebook, but if you do, you're really cutting yourself off from so many of your colleagues and family. So that means Facebook has a higher responsibility, if anything, to make sure that it is fair in the way that it implements its policies. And we have a website called onlinecensorship.org, which is run by one of my colleagues as a project with another group. Have a look at that, because that helps people to navigate the review system of the major websites like Facebook, Google, Twitter, to get their content back online if it's been taken down wrongly. And there are examples of things like, breastfeeding photos that have been taken down for nudity, that sort of thing. Also, disputes between people on the Israel-Palestine conflict that weren't hate speech but were still taken down, things like that. So take a look at onlinecensorship.org.
Can you talk a little bit about what the status of the right to be forgotten in Europe is, and whether or not that's going to be expanded to affect all global websites?
That is a really good question. For those who don't know, the right to be forgotten is part of the new European data protection law, which is called the GDPR. Actually, it's really just an extension of the data protection law they had before, but the right to be forgotten came out of a court decision, and now it's also in black and white in the legislation. And what it means is, if there is personal information about you online, in some circumstances you can request to have that taken down, even if it is, for example, an article that was written by someone else about you that contains your personal information. So in that case, there's a problem, because effectively by requesting that personal information to be taken down, you're censoring what someone else has written about you. So EFF has concerns about the right to be forgotten. Even though we do support the idea of personal data protection, of course, it's a fundamental right of privacy under both the US Constitution and the Universal Declaration of Human Rights. But the problem is, what if this right to be forgotten is applied worldwide? Remember that Equistec case that I mentioned, where Canada wanted to have the Equistec decision applied worldwide? Well, France is one of the countries that is currently in litigation to try and get the right to be forgotten to be applied worldwide. And so there's an obvious problem there, because it isn't compatible with US law. We draw the balance between freedom of expression and privacy at a different place to where Europe does. And even other countries that have more advanced data protection laws than we do, to be frank, US data protection law is kind of bad, but other countries are, in Latin America, for example, and in Asia, some of them do also recognize a right to be forgotten, but they don't put it in the same place as Europe. They don't strike that balance in the same place as Europe. So even those countries would have something to fear if the European version of the right to be forgotten was applied worldwide. So I don't have a great answer to that question, because it is a real risk. Like, we are facing the prospect of countries forcing platforms around the world to implement their national law in ways that we don't agree with. And Interestingly, one of the proposals for NAFTA, remember the North American Free Trade Agreement, which is being renegotiated now, one of the proposals from US tech companies is to have a rule in there which says to countries like Canada, hey, you can't do that. You can't enforce your laws on US tech companies in the way that you're trying to do, because it's not democratic. You only represent Canadian citizens. You don't represent the rest of the world. If you want to do something like that, you would have to go through something like the ITU or preferably the Internet Governance Forum and make some recommendations that countries around the world could draw on. It wouldn't be a law, but it would be, you know, some guidance. Or in some cases, an international treaty. We're generally skeptical of those, but in some cases, those can work. For example, we did support a treaty for the rights of visually impaired people as an international instrument. So EFF are not just cyber libertarians who think no law. Sometimes law is good, and sometimes even international law is good, but not in the case where one country's law is being applied indiscriminately throughout the world. That is something that we have a real problem with.
Yeah, I would like to ask if there are any organizations that try to support or empower those 3 principles you just presented here.
Sorry?
Those principles you presented here, are there any organizations that help to support them or empower them?
Yes, in a sense, yes. I would say that these are a version of the multi-stakeholder model of internet governance, which is a founding process principle for the internet. And many internet bodies, both on the technical side and on the non-technical side, purport to uphold this multi-stakeholder model of governance. The problem is, though, because so many people purport to uphold this principle, it's become kind of meaningless. And you have processes that claim to be multi-stakeholder, they claim to be inclusive, balanced, and accountable, but when you drill down and look at the criteria that lie behind these words, they're not satisfying those. They're not, for example, resourcing stakeholders. They may say, we've got an open door, come, but they'll have meetings in Washington, DC, or in Brussels, and you have to fly there to participate. You know, so that obviously is multi-stakeholder only in name, not in substance. So there are bodies, you know, civil society groups that are promoting these principles, but we would actually like anyone who is here or who is listening via the webcast who wants to help to promote these, to do so. We have printouts of a larger version of this infographic, which I can actually distribute to you. And if you're at a meeting which you think should be more open, should be more balanced and accountable, maybe you could hand them a copy of this flyer, and we'd be happy to talk to them some more about how they could improve their processes. We're trying to do that right now with NAFTA. I've already mentioned that a couple of times. The US government has a lot of lip service that it gives to the idea of transparency and balance in trade negotiations, but it's just not happening. So we have a civil society network called the Open Digital Trade Network, which is trying to advance these principles in the context of trade negotiations, and there are also those who are trying to advance these principles in other contexts, like at the ITU that I mentioned. But I guess there's not as large of a movement overall as we would like to make these a household name among policymakers, and so that's something we'd like to see happen.
Hey. Related to the previous question, how do you hope to see these principles like implemented in the future, like in the near future? Like, where would you start? Who would you start to get implementing these principles?
So maybe I can just continue and tell you a bit more about what we're trying to do with NAFTA. So we have been trying to get the United States Trade Representative to, for example, give copies of its negotiating texts to the public. And once it has a draft agreement after every round, it should publish that. It should allow the stakeholders that it consults with to do so openly. At the moment, they have to sign non-disclosure agreements, which means that they're basically just companies. Groups like EFF refuse to sign non-disclosure agreements, so we're not represented in their advisory process. So there are recommendations like that that we've been asking them to implement. They've not been receptive to that. So currently there is a law, a bill, I should say, before Congress which is the Promoting Transparency in Trade Act. If you would like to contact your representative to ask them to support that bill, that would be a great idea, and you can do that from EFF's website, and I'd be happy to give you a link, or else you can just search for Promoting Transparency in Trade Act. That's just one example. Unfortunately, you kind of have to do it on a case-by-case basis. USTR, ITU, as I mentioned, ICANN itself. ICANN is the international body that controls domain names. It's already multi-stakeholder in name and in various aspects. It does a pretty good job, but it could be improved. There are people looking at accountability of ICANN. There are people looking at how certain working groups are dominated by industry and how we could improve that. So ICANN is a work in progress of implementing multi-stakeholderism, and they've done okay, but we think they can do better.
Are there any additional questions? We might have time for one short question.
Hi. Yeah, you mentioned at the beginning of the presentation that you guys are trying to avoid going through the United Nations to pass legislation. Why do you guys not want to go through the United Nations for internet policy?
Well, we do work at the United Nations to some extent, particularly when it comes to human rights standards, because unlike treaties, human rights standards are, firstly, they're already agreed. We just need to work out on how they should be implemented in certain contexts, like communication surveillance and so on. And also, they tend to be a soft law rather than binding treaties, so there's a bit of flexibility in how they're applied. But as I did mention, sometimes binding treaties are okay. The Treaty for the Blind at WIPO, WIPO is the World Intellectual Property Organization, and other treaties at WIPO sometimes are the way to go. WIPO is relatively open compared to some other international institutions. Civil society groups can attend, they can hear what's going on, they can get copies of texts. So we do participate at WIPO. I've been to several of their meetings, but we are always a little cautious of giving over too much control to governments. These are intergovernmental bodies, after all. They're not really multi-stakeholder bodies in the same way as ICANN or the Internet Governance Forum. So we just want to make sure that they don't bite off more than we want them to have, in the way that the ITU was threatening to do a few years ago. So I guess we have a cautious and constructive relationship with the United Nations.
Please join me in thanking Jeremy for his presentation.